Hello my dear friends and welcome to StudyIQ. I am Joycey Joy and today in this lecture we will discuss about the section 74 of IBC or the Insolvency and Bankruptcy Code. First of all, let us understand what is the current affair that is associated with the section 74 of IBC. Section 74 of the Insolvency and Bankruptcy Code was recently invoked against a company, and this was invoked for the first time, and the reason is that the company had failed to comply with the approved resolution plan. So this is the current affair. Recently, section 74 of the IBC was invoked against a company for not complying with the approved resolution plan, and this was for the first time that section 74 of IBC was invoked against a company. So this makes the current affair, and we will see in detail what is this IBC, what is section 74 of IBC. We will also understand what are the shortcomings, what is a recent case, and also what is the way ahead. Now let us see what are the elements of IBC or the Insolvency and Bankruptcy Code. But before going on to the elements, let me give you a brief understanding about IBC. I am not going into the details of IBC because already a lecture on IBC is available on the StudyIQ channel. You can refer to that lecture for more details about IBC. But here I will give you a brief understanding about what is IBC or Insolvency and Bankruptcy Code. So it is basically a bankruptcy law of India, and it seeks to consolidate the existing framework by creating a single law. So IBC or the Insolvency Bankruptcy Code is a single law, or it is a consolidated law for insolvency and bankruptcy framework in the country. Now coming to the elements of IBC. First one, under the IBC, either the creditor, that is the bank is the creditor, or the loaner is the person who has made the default. So loaner is the defaulter. So either the creditor or the loaner can initiate the insolvency proceedings. So the insolvency proceedings on a defaulted company can be initiated either by the creditor or by the loaner. So how to initiate an insolvency proceedings? It is done by submitting a plea or an application to the adjudicating authority. So an application or a plea has to be sent to the adjudicating authority at the National Companies Law Tribunal. So NCLT or the National Companies Law Tribunal. And the insolvency proceedings can be initiated on the admission of the application by NCLT. So any party, that is creditor or the loaner, will have to give an application to the adjudicating officer at the NCLT, and once the NCLT admits the application, insolvency proceedings can be initiated. And after the admission, the lenders will have to form a committee of creditors. So once if application is admitted by NCLT, the lenders will have to form a committee of creditors, and they have to appoint an insolvency professional, that is IP. So an IP has to be appointed. And what is the role of IP? The IP or the insolvency professional will act as a resolution professional, and he will run the borrower's business in the interim period. So this insolvency professional will run the business during the interim period. And what is this interim period? The period till the resolution process is over. And meanwhile, any resolution applicant can submit a resolution plan to the RP, that is the resolution professional, and that will be placed before the committee of creditors. Now, what is meant by a resolution plan? A resolution plan is supposed to be a bid or an offer for the corporate debtor. So it is a bid or an offer for the debtor through which the debtor proposes to repay the bad debt or part of the bad debt of the corporate debtor. So here the resolution applicant agrees to pay a part of the debt or the complete debt of the debtor in this period of time, and the responsibility of approving the resolution plan, it is with the committee of creditors. So the committee of creditors will have to approve the resolution plan, and it has to approve by at least 75% of the votes in favor of the plan. And once the committee of creditors approves this resolution plan, it is subsequently approved by the AA. What is AA? Adjudicating authority. And once adjudicating authority approves the plan, it becomes a final plan and it will be binding on the corporate debtors involved in the resolution plan. So this is the entire process of IBC or creating a resolution plan. Now let us understand what is section 74 of IBC, because it is the current affair. What is section 74? Section 74 of the IBC lays down the provisions to penalize officials of corporate debtors, creditors and bidders. So it contains penalizing provisions. It is against either corporate debtors, creditors or the bidders. And this penalty would be applicable if and when any of these parties violate a resolution plan. So in case of violation of a resolution plan, the penalizing provisions are applicable to the corporate debtor, creditors or the bidders. Now the officials of the corporate debtor who violate the norms can be imprisoned for a maximum of 5 years and a penalty of up to 3 lakhs. Now this is the case with corporate debtor. Now the officials of creditors, if they make any default or if they do not comply with the resolution plan, they can be jailed for up to a term of 5 years and they can be penalized up to rupees 1 crore. Now, if the bidders, in case of bidders who violate the norms, they can be imprisoned for a period of 5 years and the penalty could be up to 1 crore rupees. Now, this provision of section 74 of IBC, that is the provision which penalizes any non-compliance with the resolution plan. So, this is required to protect the code from being taken lightly. If there is no provision for penalty and the resolution plan would not happen as such. So, this is if the resolution plan is violated, and section 74 is significant because it is important to ensure that the resolution plan is taken seriously and it is complied with. Now let us come to the recent case. We have seen that for the first time section 74 of the IBC has been invoked. So let us see what is this first case where 74th section of IBC has been invoked. So this case is related with the Liberty House. Liberty House is an international metals and industrial group. So this is a company which had made a successful resolution plan for a defaulted company, Amtech Auto, earlier this year. And the terms of the resolution plan were also approved by the adjudicating authority. We have seen that adjudicating authority is under the NCLT, National Company Law Tribunal. So the NCLT had already approved the resolution plan also. But what happened later on? The Liberty House failed to pay the banks according to the terms of the resolution plan. So Liberty House did not comply with the provisions of the resolution plan. Now what is the argument of Liberty House? Liberty House argues that there were serious issues in the information and valuation reports which were shared with the Liberty House prior to the bidding process. And because of the non-compliance with the resolution plan, the lenders to the Amtech Auto have moved to the Chandigarh bench of the NCLT in order to invoke section 74 against the Liberty House group. So the case is not very important. You just need to know that this is because there was a non-compliance to the resolution plan under the IBC. Now what happens once section 74 is invoked by the Committee of Creditors? Once the section 74 is invoked by the Committee of Creditors, it is up to the NCLT to decide on the course of action with respect to the corporate debtor. The NCLT has got two options in this regard. The NCLT can either ask or allow the resolution professional, that is the RP of the corporate debtor, to invite fresh bids. So there is one option to invite fresh bids, or secondly, another option left out with the NCLT is to penalize the bidder who has made a non-compliance, and we have seen that there are various jail terms and fines provision under the section 74 of IBC. So any of this can be invoked by the NCLT. And if in case there are no fresh bidders, the NCLT can also allow liquidation of such corporate debtors. So this is what happens after 74th section is invoked. Now let us understand what are the concerns regarding the section 74 of the IBC. First of all, the section 74 of the IBC, which provides for a penalizing provision under the Insolvency and Bankruptcy Code for the non-compliance of the resolution plan. It has not brought in seriousness into the entire IBC process. It addresses only a part of it. And furthermore, this could deter the bidders from a market that already lacks any good resolution plans. So that is one major drawback, and it is also unfair to penalize only the bidders. The litigations can happen because of other bidders or even because of the debtor, but it provides for penalizing the bidders. So that is another major concern. And in the present case, we have seen that this is the first time section 74 of IBC is invoked by the lenders. So the decision the NCLT will take in this regard will be a precedent for the future cases. You can find the PDF of this lecture on my Facebook page, and for any queries regarding your UPSC preparations, you can get in touch with me on my Facebook page, or you can email me at joycey.studyiq@gmail.com. Thank you.